How do you follow the President of the Court Act? Well, with another great panel. This is a little bit like the sort of final sessions for today, and I would say, we discuss challenges, conflicts, and this is supposed to be the Zen session. We need to try to find peace and harmony. So all our 4 speakers, that's your task. I will actually introduce all our panelists all in one go, and I will start with my colleague, Philippa Webb. She's an associate professor here at the Dixon Poole School of Law. Philippa has, I'm sure most of you are aware and familiar with all her publication in international law, but she also has a little bit of, actually, she has an impressive practical experience. She's been involved in quite a lot of practical cases. She spent some time in, several international institutions. Then, coming closer to me, Johnny Veeder, QC from Essex Court Chambers. He really needs very little introduction. I will limit myself to the essentials. Most important thing, he's a visiting professor at King's College London. In his spare time, he does a little bit of practice, but seriously, he's one of the leading advocates and arbitrator. He's a really well-established name, and really, we all sort of, look up to him. And then, coming back to next to me, Professor Panos Koutrakos, sorry, I'm getting tired. Panos Koutrakos, he's a professor of European law at City University, and if I may add, a very good friend of King's College London. Again, this audience, he doesn't really need any introduction. He's a very distinctive voice in EU external relations. He's the author of extremely important publication, and again, he's also a barrister here in London. Finally, Professor Lazowski from the University of Westminster, and again, I keep on repeating myself, you are all familiar with his works, first mostly on enlargement, then on questions relating to the application of the rule of law in specific countries, and with Poland and so on, but once again, one of the leading voices in European Union law. So it's a great pleasure to conclude, and a great honor to conclude today's sessions with our 4 speakers. One apology, unfortunately, Sonia Berger from the European Council could not be with us. We were hoping for some CETA gossips, but whatever. Well, next time. Probably, as I say, she was really sorry not to be able to make it, but, she had some urgent work commitment in Brussels. So I would simply just now ask, we're going to reshuffle a little bit the order, and I will actually ask Johnny to start the discussion. Thank you so much. It's up to you. Would you prefer to? Absolutely.
Well, good afternoon. Dialogue. For investor arbitration tribunals seated within the European Union, the problem is the ECJ's judgment in Nordsee in 1982, and since confirmed multiple times, and now specifically restated in the ECJ's judgment in Acmea in 2009-2018. An arbitration tribunal has no power to refer a question of EU law to the ECJ under Article 267 of the TFEU. And such a tribunal, whether consensually by the disputing parties under a contract or a treaty, is not a court or tribunal of an EU member state within the meaning of Article 267. Thank you. Taller than most. Now, what seemed at the time of Nordsee, almost 40 years ago, to be a decision based upon raw common sense to avoid the floodgates opening and drowning a nation court in Luxembourg, now seems to have been a retrograde step with lasting harm to the harmony if not also a common understanding of the European Union's legal order. Now, it did not, and it still does not need to be so. Long ago, under a Labour government, this country quietly subscribed to the Arab boycott of oil exports to Israel for its control of North Sea oil exports from the United Kingdom. And this policy gave rise to a commercial dispute between two oil companies, Bulk Oil and Sun International. Now, in brief, the dispute was referred to arbitration in London under the arbitration clause in the parties' commercial contract. And the sole arbitrator, a distinguished Queen's Counsel, made his award. Now, this award raised a point of EU law and EU public policy. And so the losing party challenged the award in the Commercial Court in London under the 1979 Arbitration Act. The Act provided for several means of challenge, and this particular means chosen by the losing party was an appeal on a question of law under Section 1 of the 1979 Act, English law incorporating EU law. Mr. Justice Bingham, as he then was, heard the appeal. The appeal was in turn heard by the Court of Appeal, which identified the specific question of EU law at issue between the parties. And the Court of Appeal referred that question to the ECJ under what was then Article 177 of the Treaty in Rome. The ECJ in turn duly decided the issue on the reference, and the answer to the question was remitted by the English courts to the arbitrator, who then made his final award in conformity with the decision of the ECJ and EU law and public policy. Now, this took time, it took money because it caused additional expense for the parties, but this procedure worked. And under the UK's 1996 Act, the same procedure exists, whether we're by way of judicial review of an award under Section 69 of the Act, or by way of the English Court's determination of a preliminary point of law under Section 45 during the pendency of the arbitration, or later after the arbitration award has been issued under Section 67 of the Act. It can also be used by way of defence to legal proceedings to enforce the award. So in practice, the North Sea judgment, certainly seen from this jurisdiction, should not be an obstacle to a reference made indirectly by an arbitration tribunal situated within the EU, whether commercial or an investment tribunal. Now, equally, an award made at a seat outside the EU in legal proceedings to enforce or recognise that award within the EU could lead to a reference to the ECJ by the courts of an EU member state. In reality, this mechanism and practice do not seem to have been widely used by users of arbitration. And why this is, I don't really know. Now, I recognise that in many jurisdictions, including, it seems, Germany, this English mechanism does not exist in the national law relating to arbitration. But it could quite easily be created or brought into existence by model legislation facilitating indirect references by arbitration tribunals to the ECJ through the member courts of the European Union. Now, there may be other reasons, but one reason I want to raise now is a very troubling reason. Because as time passes, it's pretty clear that we are like two ancient tribes living on the opposite sides of a large mountain. On one side, we have the EU legal tribe, and they speak their own language. And on the other, the arbitration tribe speaks what to them is a completely foreign language. And sometimes we scarcely acknowledge each other's existence. For the EU legal tribe, for example, the ECJ's judgment in Acmea is obviously correct under Article 344 of TFEU, although being mostly academics, of course, they quibble about the quality of its reasoning, and these questions have not been limited to London or London practitioners. But to the arbitration tribe, of which I'm a member, the Acmea judgment is very challenging to understand, particularly its apparent distinction between commercial arbitration, or as we heard just now, classical arbitration, and investment arbitration under a treaty. because both give rise to consensual written arbitration agreements between the disputing parties. It is not the case, as we heard, that the arbitration agreement between the disputing parties is to be found in the arbitration clause in the treaty between the two state parties to that treaty. There is an open offer by those parties, those state parties, effective under international law as unilateral declarations, to a non-party to the treaty, which is capable of acceptance by a separate document or a separate act by the investor. And that is the arbitration agreement, a consensual arbitration agreement, no different in principle from a commercial arbitration clause in a concession contract between a state and an investor. So people in my tribe ask, what is the difference between the two, which so persuaded the European Court of Justice to make its decision to effectively nullify the ACMEA awards? Now, I'm not going to try to answer that question for two reasons, because time is very limited, and also because I was a member of the ACMEA tribunal, and it's a well-known fact that arbitrators, a month later, no longer understand their arbitration awards, and are the least qualified to explain it to other people. But I do wonder if we have a problem here, because why is there no such dialogue except at meetings like this? It's a problem, I think, of the fragmentation of law, and certainly between EU law and international law. It's a fragmentation problem exacerbated by legal specialization, or rather the over-specialization of the legal community. Now, over the years also, consensual arbitration has not been well served by the ECJ or the European Commission, and that again I think is a function of this problem of fragmentation. Arbitrators like me who go back some years will never forget the European Court's decision in the von Hoffmann case, supported by the Commission, requiring arbitrators to charge VAT because, unlike lawyers, in the ECJ's view, arbitrators do not apply law, but in its word, apply only equity. And from Markbridge onwards, and you remember that case had the distinguished participation of Monsieur Genard and Professor Schlosser with their revised expert reports. After Markbridge, and after that judgment, the arbitration exceptions to the Brussels Convention and the Brussels regulations have not assisted the practice of international arbitration within the EU, save possibly, eventually, by leaving it to the New York Convention, to which all EU member states have acceded. Now, as I said, we can overcome this particular problem by further meetings like this. There was a useful meeting in Greece last year between members of the court and arbitration practitioners, simply to get a dialogue where we can understand each other's language. Now, I heard with fascination the President's speech a few minutes ago. What he said was very clear as to why the court decided ACMEA the way they did. But why isn't it in the judgment? Why is it that we have to come to meetings like this to understand why they decided what they do? They are a Supreme Court for the European Union, and one of the functions of every Supreme Court is to explain to lesser tribunals and lesser functionaries like commercial arbitrators or investment arbitrators as to how to apply EU law. And if we don't know the reasons why, if the reasons aren't in the judgment, it's extremely difficult to do. Now, we have a crisis because ACMEA is being considered by multiple international tribunals. I doubt if a single one is going to follow the result desired by the European Court. Now, that is a problem of dialogue. Now, I'm going to say it's nothing to do with me, because in 8 days, we shall be waving from our Titanic our tear-sodden handkerchiefs to all of you, wishing you well, and I do wish you well in your further dialogue and cases from the European Court of Justice.
Well, thank you very much. I announced this as the Peace and Harmony session, which I think we start exactly on the right tone. Let's just move on. I'm sure that there will be lots of questions and comments, but let's move maybe to other tribes. I don't know whether there's a security and foreign affairs tribe than European lawyers, but please, Panos, you have also your chance to contradict the president of the court on Rosa.
And I feel much more comfortable to do that because he's not here. I shall talk about judicial review in common foreign security policy. And originally I thought that this topic might seem somewhat apart from what we have been discussing at this conference. Thankfully, President Leonard's brought this within the purview of all this. Let me briefly set out the canvas. The principle of autonomy of EU law finds its genesis and development in the broad jurisdiction of the court as it is laid down in Article 19 to ensure that in the interpretation and application of the treaties the law is observed. In the area of common foreign security policy, however, things are different. This is because of the overtly sensitive nature of the policy, which touches upon the core of national sovereignty. And this was made abundantly clear in the pre-Lisbon days. Common foreign security policy was not part of the original primary EU law. It found its way into the treaty later, and in a very limited form, and while gradually strengthened in subsequent treaty amendments, it formed a separate pillar of the EU legal order. So this is the first theme of common foreign security policy law, distinctiveness. Not just in policy, but mainly in legal terms. And there is a counterpoint to this theme of distinctiveness. We find it in the Lisbon Treaty, which removed pillars and made common foreign security policy part of the unitary constitutional structure of the EU. And this is the second theme of CFSP law, constitutionalization. And these two themes, distinctiveness on the one hand and constitutionalization on the other hand, they still go hand in hand. The TEU, for instance, does not do away with the distinct nature of the common foreign security policy within the Union's unitary structure. CFSP is subject to specific rules and procedures under Article 24, paragraph 1 of TEU. The competence of the EU in this area is described separately from all the other competences of the EU. Unanimity is the rule, and no decision has been made in qualified majority voting to date. The common foreign security policy is the only substantive policy, the rules of which are set out in TEU rather than in TFEU, and the jurisdiction of the court is excluded in principle. And this brings me to the topic of my presentation. We have an exclusion from this jurisdiction. And we find this in Articles 24 of TEU and Article 2275 of TFEU. No jurisdiction for the Court of Justice in respect to the provisions relating to the common foreign security policy and with respect to acts adopted on the basis of these provisions. And we have two exceptions from this CFSP exclusion. The Court does have jurisdiction to review the legality of CFSP decisions providing for restrictive measures against private or legal persons, and the Court does have jurisdiction to ensure compliance with Article 40. I remind you, Article 40 is the non-effect clause. Anything the Union does in CFSP must not affect the powers and procedures of the EU in all the other areas, and everything the EU does in all the other areas must not affect the powers and procedures in CFSP. So this is the canvas, the CFSP exclusion and the two exceptions. So what we have seen in the last few years is some case law where the court appears to place increasing emphasis on the theme of integration rather than that of distinctiveness. And it has done so by enhancing its jurisdiction in a number of ways. It has done so in procedural terms, and we have the judgments in the cases about the EU agreements with Mauritius and Tanzania, agreements about the transfer of those suspected of piracy. The court tells us these are CFSP agreements, but they are concluded on the basis of Article 218 of TFEU. Therefore, we have jurisdiction over their adoption because Article 218 is not excluded from our jurisdiction. We also have the Rosneft judgment, and we heard President Leonard's talk about this earlier on. But the court has also enhanced its jurisdiction in substantive terms. So we have the L'Italiana judgment, a decision about awarding a public contract. The decision was taken by the head of EULEX Kosovo, a common security and defense policy mission. The court tells us that this decision gives rise to expenditure, which, in accordance with the treaties and EU's financial regulation, were charged to the EU's general budget. The court has jurisdiction over the budget. The court has jurisdiction over this CFSP decision. We have the H judgment, a case about the deployment of an Italian magistrate seconded to the mission in the regional office in Bosnia and Herzegovina. The court says we have jurisdiction over this. This is about personnel. It's an administrative matter. So what we find is a common thread in this case law. The exclusion from the court's jurisdiction is a derogation from the rule of general jurisdiction under Article 19. As an exception, it must be interpreted strictly. And this approach to the interpretation of exceptions, of course, is not unfamiliar. We are familiar with this in the context of the internal market. Any exception to free movement principle is interpreted narrowly. The terms, however, in which this rule exception principle is couched in the case law in this area reflects the constitutional perspective through which the court is said to approach the question of jurisdiction. It may well be argued that, in fact, it is the jurisdiction in CFSP that is exceptional, the rule being that the court has no jurisdiction in CFSP. Now, such an approach would be consistent with the distinct nature of CFSP within the Union's constitutional order. It would therefore reflect the logic of the exclusion, and it would suggest that the exceptional jurisdiction to rule on compliance with Article 40 and the legality of CFSP decisions targeting natural and legal persons would be interpreted narrowly. This, however, was not the approach that the court adopted. And in the choice the court made to interpret this exclusion broadly, we may detect narrowly, we may detect two main characteristics. We have a choice. And the first characteristic of this choice is the degree of considerable judicial creativity which we find. And this is not without problems. The judgment in H, for instance, I shall not going to bore you about this. I've been asked to speak for 15 minutes, and I shall try and do that. But I shall just say two things about this. One is we see a strikingly broad brush approach that the court adopts in order to substantiate the existence of its jurisdiction. And we also see an emphasis on the administrative aspect of this case. It's as if the court were rather keen to distinguish between administrative matters and operational matters. It was as if operational matters clearly would fall beyond the scope of the court's jurisdiction. And yet the decision was about, the measure in question was a decision of the head of mission as to where a magistrate should go. If a decision of the head of mission as to where a magistrate should go is not an operational measure in the context of the rule of law of mission, what is? So that is the second aspect we see here. We see a tendency towards downgrading the operational and hence sensitive nature of staff decisions in order to assimilate them to management decisions. Now, I have talked so far about the substantive scope of the jurisdiction of the court and how the court has enhanced it. But I could also talk about the procedural scope of the exclusion. I shall not say very much. President Leonard's talk about how the court rendered Rosneft into the treaty, preliminary references from domestic courts, and how the court held that these would fall within the jurisdiction of the court. President Leonard's presented this as the inescapable conclusion in the context of the case. Well, some might argue that this conclusion is not all that inescapable, particularly because it is not fully supported by the wording of the provision. It may well be the case that it might be desirable for domestic courts to be able to make such a reference. This will be good for the coherence of the union legal order. Nonetheless, this was a choice that the drafters of the treaty did not make. So what we see in Rosneft is quite an integrationist logic, which may raise questions about the consistency with the wording of the treaties, and in any case it tells us something about the normalization of CFSP within the Union's constitutional order. The distinctiveness of this policy is by no means as pronounced any longer as its distinct legal features might suggest. And this approach brings CFSP closer to the mainstream legal principles that apply to the other areas of EU law in general and external relations in particular. There is an interesting point, of course, about all this. In Rosneft, we do not see this type of boldness that the court showed about preliminary references on the substance of the case. In fact, the judgment is characterized by a balance between principle and pragmatism. Once it had construed its jurisdiction very broadly, the court went on to dismiss all the claims made by Rosneft, that is the target of the union's restrictive measures, and to point out the broad discretion enjoyed by the union's institutions in this area. And this balance between boldness on the scope of the court's jurisdiction and caution on the substance of the dispute may appear to suggest that the overall approach emerging from Rosneft would not really pose a threat to the distinct nature of CFSP. In other words, the union's judges would not really interfere with the substance of the fundamental choices made by the union's institutions unless something obviously has gone wrong. And there may well be something there in the context of trade measures with foreign policy implications. I argued quite some time ago that while it was keen to construe the scope of EU law as it then was, EC law as it then was quite broadly, the court was loath to interfere with the substantive policy choices made by the EU's institutions in the field of foreign security policy. If that, however, were the case, we have three problems. The first problem is about the wording of the treaties and the logic of the CFSP exclusion from the court's jurisdiction. The approach of the court is quite creative with the former, quite selective with the latter. It does reflect the integration of CFSP in the EU's constitutional order, but it seems to ignore its distinct position. The second problem is that the case law I've referred to seems to expect almost member states to show faith and trust, to trust the court to exercise its broadly construed jurisdiction with appropriate deference to the substantive policy choices that the EU institutions make in this very sensitive area. And this leap of faith would compensate them for the greater involvement in CFSP that the court has read into the treaties. This leap of faith, however, entails uncertainty, as it would rely upon the EU judges to take it upon themselves on a case-by-case basis to respect the broad discretion that is inherent in the conduct of CFSP. And we have a third problem. The case law so far equates impliedly judicial review with the court's jurisdiction, and it appears to dismiss national courts. And it's not clear why that is the case. After all, domestic courts are bound by the duty of cooperation in general, Article 4, Paragraph 3. They are bound by Article 19, Paragraph 2, to provide remedies which are sufficient to ensure effective legal protection in the fields covered by EU law. CFSP falls within the scope of union law, and it is worth recalling that the court itself has referred to domestic courts as the guardians of the EU legal order. And the rule of law and fundamental human rights apply to CFSP as a matter of EU law too. After all, remember, President Lenin reminded us that in Article 2 we find reference to the values of the European Union, and the Charter also applies to CFSP. So where does this take us? In the absence of access to the Court of Justice of the European Union CFSP matters, jurisdiction remains with domestic courts. The union courts do not have inherent jurisdiction just because matters of union law are involved in a particular case. And this conclusion is also borne out by Article 274 of TFEU, a provision which refers expressly to actions involving the EU as a party that are not excluded from the jurisdiction of domestic courts. It is also borne out by Article 47 of the Charter, which refers to an effective remedy as a matter of EU law before a tribunal. And yet, while we find broad statements in the case law about the role of domestic courts when it comes to protecting or enhancing the jurisdiction of the Court of Justice, we do not see a corresponding willingness to actually trust such courts. CFSP is a case in point. In fact, ISDS and autonomy is another case in point. Let us remind ourselves of Vacmer. There is delicious irony in the fact that the court's concern for the existence of the power of domestic courts to refer questions would be expressed in a judgment which was in it itself a reference from a German court. Now, in the area of CFSP, the role of domestic courts and the issues that this might raise, there is debate about this. This was something that Advocate General Cocotte elaborated on in her opinion on the accession to the European Convention on Human Rights. And Advocate General Wahl also elaborated on this in his opinion in Age. And precisely because we're talking about involving domestic courts in an EU policy where the court has no jurisdiction, things may well turn out to be messy. How far would domestic courts go in exercising their jurisdiction? What kind of standards would they apply? And what about photo frost? Messiness, however, is the inevitable consequence of the fundamental choice made by the drafters of the treaties to exclude CFSP from the court's jurisdiction. And we know how to live with messiness in the EU legal order. We have messiness in many issues. Supremacy, for instance. Let's compare the understanding of domestic constitutional courts of what supremacy means with the understanding of the Court of Justice of what supremacy means. And messiness may not necessarily lead to mess. Neither does it have to undermine EU law. Consider two examples very briefly. There was a judgment by a high court in this country last month where these issues were raised. Can the union be liable in CFSP in a case where the court would have no jurisdiction? The case was dismissed by the High Court, but what is quite interesting is that the court is quite keen to ensure that the jurisdiction of the court is interpreted very broadly. We have a domestic court there keen to protect the broad jurisdiction of the Court of Justice. We have a similar development in the area of ISDS, Mikula, for instance. We have the High Court in this country, which was keen to ensure that whilst the Exit Convention would be complied with, EU law duties would not be violated. And it did this in a very elegant manner. It accepted the registration of the arbitral award, but proceedings were stayed until the General Court would rule on the challenge against the Commission's decision in that area. And this was a judgment which was upheld on appeal last summer. So in some ways, there is some irony in the developments that I have just discussed. The case law of the court seems to expect a leap of faith on behalf of the member states, and yet it does not seem too keen to make this leap of faith itself when it comes to acknowledging the role of domestic courts, not as a matter of principle, but in practice. Thank you.
Thank you very much. That was excellent, but I'm not doing very well on my idea of peace and harmony. We start with tribes. Now we actually have messiness and a very lucid demolition of the Rosner judgment. Anyway, I see that Adam in his title has some chocolate. So I wonder whether we're now getting a little bit of sweetness or maybe some slightly more peaceful messages. And obviously Adam is going to discuss one of these most recent Swiss new agreement. So I was saying, TTIP.
Yes.
Adam, that was yours.
Thank you very much indeed. I shall not be discussing US for sure. Don't know much about it. I mean, the TTIP, to be honest. Right, I'm going to talk about EU-Swiss relations, which for many, many years were ignored in the United Kingdom as sort of a niche topic. But suddenly, of course, after what happened 3 years ago almost, in 2016, the bilateral EU-Swiss framework became quite popular among certain circles, if only for a few minutes when they realized what actually it meant. I called it once a box of chocolates, and I think the draft agreement which we have on the table at the moment is just another layer in the existing box of chocolates between the EU and Switzerland. Now, what these relations really are in 2019, I will use two quotes from the most recent EU Council conclusions on EU-Swiss relations. The Council says EU and Switzerland are close allies. And it also says the EU and Switzerland continue to enjoy, watch out, a strong and stable relationship. That sounds familiar, right? But this relationship is actually strong and stable, although, as I will explain, quite rocky indeed. Now, let me first briefly talk about the scope of cooperation between the EU and Switzerland. Now, legally speaking, we have more than 120 agreements dealing with anything starting with trade in cheese and wristwatches and ending with the most controversial of them all, a free movement of persons agreement. But the scope of cooperation goes beyond the law, goes into politics. Switzerland is heavily following the European Union when it comes to CFSP matters, for instance, participates in missions, EU missions abroad, and most recently even linked itself to the greenhouse emissions on the EU side, and also tries to, being a member of Schengen, associated though, to implement the European agenda on migration. So the substantive scope is very, very broad indeed, both legally and politically. But the legal framework, as I've explained, although very briefly for now, is very, very patchy. Now, if we put it against the legal frameworks with other neighboring countries that the European Union has, it's very much different. It's very idiosyncratic. If we look at EEA, of course, we have one main agreement with Iceland, Iceland, Norway, and Liechtenstein. We have a few flanking agreements, but there is one core agreement. The same goes for relations with the Western Balkan countries. You have always an association agreement, the main one, and flanking agreements filling in the gaps. The same goes for the Euromed countries, and the same goes for some countries of former Soviet Union, mainly Ukraine, Georgia, and Moldova, which have very, very comprehensive free trade association agreements. But what we have with Switzerland is this very fragmented framework. And honestly, that's one of the lessons that we and EU has learned the hard way. If you start having with a third country such a fragmented framework, then it's very difficult at some point to say, okay, shall we codify it into one big agreement, put it under one umbrella, let's make it basically straightforward. It's very difficult. Once you reach a certain stage of patchiness, it's very difficult to turn the tide. Now, very briefly in the history of EU-Swiss relations. It all started really back in the 60s with the first agreements between what was then EEC and Swiss Confederation were signed. The two milestones that are so problematic in 2019 are so-called Bilateral 1 and Bilateral 2 packages. And their origin goes to the European Economic Area, as a matter of fact. Switzerland was one of the countries that was heavily involved in the brainstorming about the EEA throughout the 1980s, and then in the negotiations of the EEA. And then what happened was that Switzerland, as Switzerland does, had a referendum on the EEA, where the Swiss said, no, thank you. This is very interesting, but we are not into it. And they did so with the majority of people and cantons, which was a constitutional requirement. So almost as EEA was turning into reality, Switzerland has pulled out. Now, to surprise of some people at the European Commission, Swiss authorities came back to the Commission about 3 months later saying, why don't we chop the EEA into small bits and pieces and have more bilateral agreements, but sectoral? Now, the initial reaction of the Commission was, you must be joking. We have this huge problem because of you now, because we need to remove parts from the EEA agreement, but you now want to have it through the kitchen door. But a year later, the Commission changed its mind, published a communication saying, that's actually a good idea under one condition. We get this box of chocolates, and we're going to put in the chocolates that we really like, both sides. So as far as we are concerned, free movement of people. And then suddenly Switzerland sort of said, oh, right, that's going to be not so easy. So we ended up with bilateral 1, the package of 7 agreements, which were signed in 1999. But they were signed on the European Commission's terms. Either all of them enter into force or none. They have a guillotine clause. Now, the downside of it is that if one of them is terminated, the whole package goes to the bin. And that is now a bit of a problem in bilateral relations. This was followed by 2004 bilateral 2, where, for instance, you have a Schengen agreement. So Switzerland became associated with Schengen. And in the years after bilateral 2, we had several agreements concluded on cooperation with Europol, with Eurojust, cooperation with the European Defence Agency, cooperation between competition authorities, and so on and so forth. So the number is over 120 agreements as we speak. Now, once it all entered into force, it became rather quickly clear that things do not work. Why? Because the agreements, some of them, require application of EU law. So you have lists of EU acquis that has to be followed by Switzerland. But largely, with the exception of Schengen and Dublin agreements, the system is static. So whenever EU law changes, Switzerland is officially approaching a joint committee, or are you with us or not? And Switzerland feels quite free to say no. So in free movement of persons, we have a very bizarre situation where in 2019, the bilateral framework with Switzerland goes back to the 1960s. So what we've repealed in the EU effectively from 2006. And Switzerland has been asked several times, why don't you accept Directive 2004/38? No, thank you. Are you sure? No, thank you. Are you sure? No, thank you. So this ping pong has been going on between Bern and Brussels for quite a while now. Up to the point where in 2008 and then especially in 2010, the Council conclusions on EU-Swiss relations were very negative. Now let me quote one paragraph. Due to the lack of efficient arrangement for takeover of new EU acquis, including ECJ case law, and for ensuring supervision and enforcement of the existing agreements, this approach does not ensure the necessary homogeneity in parts of the internal market and of the EU policies in which Switzerland participates. This has resulted in legal uncertainty for authorities, operators, and individual citizens. The gist of the conclusions is we can't go on like this anymore. And that was the point where EU started to approach Swiss authorities saying we need to have at least some sort of institutional agreement. Because what we have, Panos referred to messiness, I would say organized chaos in this particular case. Because we don't have joint institutional framework. Every single agreement has its own joint committee of sorts. The EFTA court has no jurisdiction to hear references from Swiss courts. Switzerland treats it as a static instrument, so they really do box of chocolates integration. They follow pieces of EU acquis they prefer, and that's about it. Now, to add to it, in the meantime, Switzerland had a couple of referenda on free movement, forcing the authorities to actually go against the free movement of persons agreement, putting the EU in a pickle. Because, of course, if the EU then wants to terminate the agreement on free movement of persons, the whole bilateral 1 package goes to the dustbin. And then the question is, can you have Schengen agreement without free movement of persons? So that may affect also bilateral 2. So that's why EU has been initially quite cautious, then more pushy, and now we are back to square one, really. So EU tries to be gentle but pushy at the same time, trying to do something. And what happened was in 2014, the negotiations commenced on the institutional agreement. Now, addressing 3 main dossiers. First of all, what happens with new EU legislation? Should Switzerland have better access to decision-making in the EU, or rather decision-shaping, than it has at the moment, especially when it comes to non-legislative acts, where the access for civil servants is not that obvious from third countries? Second, whether Switzerland should be obliged to accept EU law as it changes within the scope of the bilateral agreements, and if so, which ones? And third, how these agreements and EU acquis should be applied in Switzerland. Should there be any cooperation between the Court of Justice and Swiss, for instance, Supreme Federal Court? And should there be any mechanism for dispute settlement should Swiss courts interpret EU law differently than the Court of Justice? Now, the end result of 4-year-long negotiations is an agreement which was, the negotiations of which were completed in the late autumn last year. What has happened since? Switzerland, without telling the European Commission, decided to launch public consultations on the agreement for 6 months. Commission was not very pleased, and the same goes for the Council, which in the previously mentioned conclusions of February this year said, "We strongly regret that the Swiss Federal Council did not endorse the outcome of December 2018 agreement, but we appreciate that you are now engaged in public consultations." But the political mood in Switzerland is not very permitting. So what I'm talking about perhaps will never enter into force. So what are the solutions? Well, first of all, the scope of the agreement. It only will apply to a handful of bilateral agreements which grant Switzerland market access. So not the entire bilateral package, but just a selected list of agreements, in particular, free movement of persons. It also envisages more dynamic system. So Switzerland will be expected to follow EU legislation in these areas as it changes. And this should include both legislative acts, EU legislative acts, and non-legislative acts. Furthermore, Switzerland, as a sort of reward, would have more access to EU decision shaping. So it would be invited to participate in relevant working groups. There would be an ex-ante sort of warning system whereby Commission would inform Switzerland on regular basis about incoming proposals for delegated or implementing acts. And there may be quite a lot in this respect, because on the list we not only have free movement of persons, but also air transport, carriage of goods and passengers by road and rail, trade in agricultural products, and mutual recognition of technical standards. So a lot of technical legislation there. So Switzerland will be expected to follow this legislation pretty much on automatic basis. Should it wish not to, then that would potentially trigger a dispute settlement mechanism involving, at the early stages, joint committee, and in extreme cases, arbitration. Courts or panels established by the permanent court in The Hague. That would be basically the outlet for such, to help basically such arbitration panels. There is one thing, though, that Switzerland managed to negotiate that should acceptance of EU acquis require, for instance, a referendum, there would be some sort of transitional period that those needs would be accommodated. But what about interpretation of these rules? That's where it gets very, very interesting. Well, first of all, the draft agreement makes it clear that Swiss courts should follow interpretation of the Court of Justice. Of course, it's phrased in a very diplomatic way, but we know what that in reality means. Second of all, there should be regular contact between the Court of Justice and the Supreme Court of Switzerland, Federal Supreme Court. So there should be a platform for cooperation between two Supreme Courts in the respective jurisdictions. But what if Swiss courts decide to, or authorities decide to interpret EU law in a different way? Then we have a very sophisticated mechanism involving, again, a joint committee at the early stages, so when things are fairly peaceful, and then involving arbitration. And should the main issue be interpretation of EU law, watch out, the arbitration would have the obligation to send a reference for an opinion to the Court of Justice. So we have an equivalent of preliminary ruling procedure. Now, this is all not unheard of, at least partly, because we see similar arrangements in the withdrawal agreement, which of course we don't know if it will enter into force. Sorry, I was supposed to be peaceful, but I mentioned Brexit. And similar arrangement is likely to appear in the future agreement, if there is any, at least if we take seriously the wording of the declaration that was approved and will be attached to the withdrawal agreement if we have it. Now, will it enter into force in relation to Switzerland? Of course, we don't know. But this is a very good lesson for the United Kingdom, I think, at the stage where we are at the moment. EU has clearly an upper hand here. The Council conclusions make it absolutely clear that if this agreement is not approved, so it doesn't enter into force, we can forget about negotiations in other areas, giving Switzerland more market access in terms of the internal market. The wording is very, very strict, and I quote, "It is a precondition for the EU for conclusion of future agreements on Swiss participation in EU internal market." So clearly here, the EU is having an upper hand, so we can learn definitely something from this. How will this story end? I actually don't know. We have to wait and see for the public consultations to be over, and then what the decision will be. But as I said earlier on, the winds are not very permitting. And since Andrea asked me to end on a peaceful note, I shall say instead of the traditional thank you, namaste.
This must be the very first session with all the speakers are conjuring against the chair. I mean, yeah, have I done something personal? Well, so we had tribes against tribes, messiness, and now organized chaos. We're doing extremely well.
This is not disorganized.
This is not disorganized. So all my hopes are now vested on Philippa Webb. And now I start, because the title is obviously the EU, Unifying or Fragmenting Force in the national law. So I start to fear a little bit the answer. But anyway, Philippa.
You may be disappointed, Andrea. I start with thanks and congratulations to my King's colleagues on a superb conference so far. So fragmentation, in the sense that I'm talking about it, can be in two ways: genuine fragmentation or apparent fragmentation. Genuine fragmentation occurs when judicial decisions give rise to conflicting developments in the law. This is either unconscious due to a lack of awareness of other courts' decisions or a conscious departure from existing case law. Cases of genuine fragmentation are rare in standing courts with public decisions. There's a greater risk in ad hoc tribunals that may or may not have public decisions. Apparent fragmentation arises when judicial decisions appear to be conflicting, but these variations are due to contextual factors, and the underlying legal reasoning can in fact be resolved and rendered compatible through clarification and interpretation. And Judge Pakar earlier today gave the example of the ICJ and the ICTY having a dialogue in this sense. What we're aiming for in the international legal system is not uniformity, but unification or integration. This is where similar factual scenarios and similar legal issues are treated in a consistent manner, and any disparity in treatment is explained and justified. And the desired outcome is harmony and compatibility, but allowing for minor variations and the tailoring of solutions. I'm going to focus on the interaction between the CJEU and the ICJ, which is, as we know, the principal judicial organ of the UN and a symbol of general international law. This is not a rigorous empirical exercise. I have not had time to analyse the 11,000-odd CJEU judgments. Instead, I've looked at a sample of cases where the court has directly cited the case law of the ICJ. And I've also looked at the very small sample of one judgment where the ICJ has cited the CJEU. Now, we know citations are an imperfect metric. We don't know how many times the CJEU could have cited the ICJ but chose not to. We don't know what happened in the deliberations and the exact reasons why a decision was ignored as irrelevant or perhaps exotic. But what I'm interested in is the general posture and attitude of these two courts to each other. And I particularly want to engage in with some recent writing by Eva Cassotti on the CJEU's dialogue with the ICJ, and she characterised that dialogue as follows. The CJEU has proven, so far at least, to be a shy disciple rather than an inquiring peer, showing a high degree of deference to the case law of the ICJ. But I do not perceive a shy disciple in the CJEU, and that is certainly not the impression given in the papers of this conference today. I rather see a robust and independent court that wishes to avoid fragmentation with international law, but also has little incentive actively to promote integration through dialogue. So I'm going to briefly look at the legal basis for integration, the actual practice, and then give three brief explanations for the limited dialogue we see in this area. So we've already been referred to Article 3.5 of the TEU, which says that one of the objectives of the EU is, in its relations with the wider world, to have the strict observance and development of international law, including respect for the principles of the UN Charter. Article 21 is also relevant, with principles inspiring the Union's external action, including respect for the principles of the UN Charter and international law. But how does this play out in actual decision-making? 35 CJEU judgments have directly cited the ICJ since 1955. Citations have also appeared more frequently in the opinions of the Advocate General. And as I said, one ICJ judgment has cited the CJEU since 1946. These are small numbers, but what we're looking for is the posture of the courts towards each other. Let me give you a typical citation of the CJEU to the ICJ, and this is from the Hellenic Republic and the Commission of the European Communities, 2007. It says, "The court would point out that the principle of good faith is a rule of customary international law, the existence of which has been recognised by the Permanent Court of International Justice and subsequently by the International Court of Justice, which, consequently, is binding in this case on the community and on other participating partners. And that principle has been codified in Article 18 of the Vienna Convention on the Law of Treaties. It should also be noted that the principle of good faith is the corollary in public international law of the principle of the protection of legitimate expectations, which, according to the case law, forms part of the community legal order," citing Opel Austria and Council. What are the features of this type of citation? And this is very typical of the 35 judgments. We have a brief citation of an ICJ case for a rule of customary international law. There's no further examination of state practice or opinio juris. The ICJ is cited as an indicator of the state of public international law. We then have a link to a treaty, but more importantly, we end and put emphasis on the case law of the CJEU and the community legal order. Another more recent example is the Whiteman case from last December on whether Article 50 can be unilaterally revoked. And the court had the opportunity to deliver a judgment based on international law principles, but it chose to assert its central role in the European legal order. It said, "It must be borne in mind that the founding treaties, which constitute the basic constitutional character of the European Union, established, unlike ordinary international treaties, a new legal order possessing its own institutions. and the autonomy of EU law with respect both to the law of the member states and to international law is justified by the essential characteristics of the European Union and its law, relating in particular to the constitutional structure of the Union and the very nature of that law. As Professor Tribunals observed this morning, this is autonomy as self-referential blueprint. The Advocate General's opinion in that same Whiteman case had relied heavily on the Vienna Convention on the Law of Treaties and cited ICJ case law. But by contrast, the judgment starting point is the specific constitutional features of the European Union. But the ICJ does not fare much better when it comes to the CJEU. The only ICJ case that referred to a CJEU judgment was the application of the interim accord between the former Yugoslav Republic of Macedonia and Greece. And behind this very technical case was the naming dispute, which has only very recently reached some resolution. And in that case, the ICJ cited Commission in Italy and Commission in Sweden in order to interpret Article 22 of the interim accord. What explains the postures of the CJEU in particular? And I want to briefly consider three aspects: its institutional features, its sense of identity, and the relationship between jurisdiction and applicable law. Some features of the CJEU militate against proactive dialogue with the International Court of Justice and other elements of international law. The Court does not publish separate opinions, which makes it difficult to assess whether in practice public international law issues have been discussed. It doesn't have a provision in its statute like Article 38(1)(d) of the ICJ statute, which provides that judicial decisions are a secondary source of law. There's not necessarily an oral hearing. There's a large volume of cases it has to process. And perhaps there's even the practical matter that it's located in Luxembourg compared with the gathering of international courts in The Hague. But the second feature, which I think is even more important, is a sense of identity. The CJEU doesn't tend to see itself as an international court. Last year, President Leonard said in a speech that the court is the guarantor of the rule of law within the EU. Its role is in effect to act as both the constitutional and supreme court of the European Union. And today he defined autonomy as the European Union legal system functioning as a self-referential, complete legal system. And I would add to this, hopefully not contradict, that this does not mean it is a self-contained system in the sense that it excludes the application of general international law. And his reference to the Western Sahara case showed that there is that reference. The Court of Appeal of England and Wales in 2017 actually commented on the role of the CJEU, and Lady Arden sat in that case. And it said, tellingly, "We accept that the CJEU's primary role is to decide matters of EU law. However, its role with regard to international law is just like that of a domestic court. It may be necessary for the CJEU or a domestic court to decide directly or indirectly a question of international law in order to decide disputes properly brought before it. And in deciding such questions, it has the power to do more than make a passing citation. And I would say that we would all benefit from its greater engagement in dialogue and the promotion of integration." The third feature or explanation is the relationship between jurisdiction and applicable law. The logical sequence of decision-making is jurisdiction, applicable law, interpretation, application. But we all know that these categories are not neatly separated. Application leads to some interpretation, and provisions on applicable law and jurisdiction can interact. The CJEU is highly aware of its jurisdictional reach, emphasising the exclusivity of its jurisdiction over and over. And this has led it to keep a very tight rein on what it considers its applicable law. But it is possible to safeguard the integrity of its exclusive jurisdiction and take a broader approach to applicable law, or to use international law as an aid to interpretation of European law on a more frequent basis. So in conclusion, what we see is not genuine fragmentation, but we see a risk of apparent fragmentation due to a lack of deep engagement. This is not a product of shyness or deference, but I think instead due to a strong sense of self and confidence and a concept of autonomy that can be equated wrongly, I think, to being self-contained. Thank you.
Thank you very much, Philippa. You see, you can count on good colleagues. You know, I feel a little bit better now. Some good words. And I was, while you were talking, I mean, maybe I'm wrong, but I think one of the most comprehensive citation of the International Court of Justice by the ECJ was in the Racket judgment on termination of agreements, which, is now back in fashion.
Yeah, exactly.
Exactly.
Article 62, yeah.
Exactly. I thought it's slightly, ironic, but, it's one of the stories. Anyway, we are actually, all of you have been really good with time, so we're just probably going to allow a quick round of, a few extra minutes if there are any discussion, any comments, and then we can try to pick up a few questions. This gentleman there.
Right. Thank you very much. My name is Szilárd from the University of Oslo. I have a question to Professor Lazowski. When the draft for the withdrawal agreement came out, I was actually told by Benedict Pirker, one of the editors of the European Law Blog, that they actually followed the model for dispute settlement put in the EU-Swiss agreement. But then, if you look at it, the first question is this compatible with EU law or any type of award that it would deliver? Because it says in both the the UK withdrawal agreement and the EU-Swiss agreement that they have to refer a question to the Court of Justice if it's a question of interpretation of EU law or compliance of, for example, the United Kingdom with European Union law. But how would then the Court of Justice accept such a referral? Because the international treaty says the Court of Justice can accept it. But how is that to be squared with the Court of Justice's case law? Is this an independent court? Yes, maybe no. Is this a court of a member state? I would hardly doubt it. Is there some special link to the member state legal orders? I would also doubt that as well. So what is your opinion? Like, are we in our quest to check compatibility of very well or more prominent international courts with EU law, neglecting a bit what exactly is included there as these PCA tribunals?
Thank you very much. That's a very, very interesting point, and honestly, I've been thinking about that. Also, considering whether that would fly with the Court of Justice, should, for instance, one of the four subjects entitled under Article 218(11) request an ex ante opinion before the agreements are signed. Because yes, you, for instance, have it's an obligation to make a reference if there is a doubt about interpretation. But what if the arbitration panel decides to follow Act Clare, for instance, Silfit ruling, so apply it mutatis mutandis, and then decide to not to refer? And we know what is the default reaction of the Court of Justice when it sees another court, potential competitor on the horizon. It's the default reaction of a cowboy entering a bar. Guns, bang, that's it. But that's, of course, a hypothetical scenario if one of the four subjects entitled to send a reference, to send a request under 218 does that. Now, frankly speaking, this is not, I of course agree that Brexit agreement and the political declaration in that section on the future agreement and its institutional setup, it follows this model. You read both and you think, well, that looks very much copy-pasted almost. But that's not entirely new thing, because, for instance, in the agreement with Ukraine, association agreement, there is such an option that the joint dispute settlement body can send a reference to the Court of Justice. And we also have such an option in the civil aviation agreement with the Western Balkans. That was, if I'm not mistaken, the first agreement where such an option was provided. But how would that work, frankly? I don't know. I suppose that would be just, in real life terms, I don't think the Court of Justice would apply the the test for definition of court, or no, that's an international treaty that EU concluded that requires that. But I do agree that it is, from the legal point of view, raising a lot of questions.
Some instruction can come from the opinion in CETA as well.
Yeah.
I think there was a point, probably the other side.
I basically wanted just to confirm, I think, Philippa's idea that the court, the ECJ, doesn't quite perceive itself as an international court. I think that's also reflected in the exchanges that are going on. So there's meetings of international courts where ICJ judges meet ITLOS judges, but I'm not aware of the ECJ ever having been invited or having tried to join. On the other hand, the ECJ regularly meets national courts and national constitutional courts, national supreme courts. So maybe over time we've seen a development in the self-perception of the court from originally thinking of itself as more of an international court to now perceiving itself more to be somewhat of an intermediary, really of an autonomous area, but closer to a national supreme court, constitutional court, rather than an international court. And I don't, on the arbitration point, isn't this, I don't think this would be under Article 268, right? That would be under Article 272. And we've seen other uses, more creative uses of the ECJ, also in bilateral tax agreements in the Austrian case, which was also, of course, under a separate article of the TFEU, where cases were referred to the court. It's peculiar to see if this becomes more common, how that will change the nature of the court.
Can I add something to it? Yeah, sure. Just on the international. If I may just add one point to what the gentleman has mentioned. There is a pending case at the Court of Justice which really will require, if it's admissible, the court to act as an international court. It's Article 259 case, Slovenia against Croatia, which although technically speaking is about, for instance, fisheries policy and similar relevant legislation, but what is at the heart is the dispute between the two countries about the border. Where is the border?
That's for next year conference. We might have time just really for a brief last question, if there is one, because I saw that. Are there any final comments? Because as I said, we are a little bit running late. So what we're going to do now, like in theater, we're going to have an extremely quick turnaround, and we will invite Baroness Faulkner to say a few closing words. But before doing that, I was trying to be light, but I really believe that what Johnny just said, that these kind of meetings are actually about finding common grounds, are about averting risk of further integrations or disintegration. So once again, I really enjoyed the session. Thank you so much. It was really, really good. Thank you so much.